New changes to immigration rules came to effect today, 3rd August 2026. In this video, I will explain everything that changed in the immigration rules from today. But before we go into it, please like this video to support the work we are doing on this page. Save the video for your reference. Share with as many people as possible so that they could see and understand these changes. And if you have a comment or question, leave them in the comment box. Now, what changed? The first thing that changed from today is related to criminal convictions. Before now, every criminal conviction for up to 12 months imprisonment would impact negatively on any application by the persons concerned. But from today, this same rule will apply to those who have suspended sentences. So suspended sentences for up to 12 months will now carry similar implication to those convictions for up to 12 months. The second thing that changed today relates to asylum seekers. Before now, if an asylum seeker missed an interview, they could apply to submit further information to provide further information that they would have provided through that interview. That also changed from today. The Home Office can now disregard the request for such submission of further information if the Home Office determines that the basis for application for asylum is unfounded. The third thing that changed today is related to those whose visa applications were refused and the refuser came with immigration bail. People on immigration bail are not allowed to make any application, particularly on the point-based system. That has now changed from today. If an application was refused and the refuser comes with immigration bail, effective from today, such persons can still make application within the 14-day grace period for making an application even when the applicant is an overstayer. That is a positive change that favors migrant. The fourth thing that changed today is related to the transitional arrangement for skilled worker visa holders post the cutoff date for skilled worker visa in 2027 and 2028. Before today, the transitional arrangement was to cover those who had already applied for their visas before those cutoff dates. But today, that was fixed to include those who would have a COS at the cutoff date, but for one reason or the other, they might be unable to have submitted an application yet. They too will be covered by the transitional protection. And the fifth change in the immigration rule today is about how children can apply for settlement in the UK. Before today, a child can apply to settle in the UK if the child has at least one parent who is present and settled in the UK. Being present and settled in the UK means that that parent either hold ILR or they are British citizen. So a child could apply to settle in the UK if one parent is present and settled and the other parent is either applying to enter or to remain in the UK with a limited leave to remain. The child could apply for settlement. That changed today to include close relative, meaning that even when there is no parent who is present and settled in the UK, but there is a close relative, an uncle, auntie, or a grandparent who is present and settled in the UK, a child can apply to settle with such close relative. But for this application, for this change to apply, that close relative must be present and settled in the UK. And secondly, that close relative must be the only person who is available to care and look after the child, meaning that maybe both parents are dead or otherwise are not available to care for the child. These are the changes to immigration rules effective today, 3rd August 2026. This is my immigration fact check 051. 001 to 050 can be accessed in my profile. Don't forget to like, share, save, leave a comment in the comment box. Thank you, and I'll see you again.